And we are back on Open Line. I'm Chuck Long here with you for the hour. One of our favorite hours here on Open Line. It is Ask an Expert, Ask an Attorney. And we are talking with Kevin Kennedy from the Kennedy Law Firm. So many of you online. Kevin, we're going back to the questions. And Kevin, we did have a follow-up too on that last question, which kind of basically Benita had called in about an accident that she was involved in. And you were talking about the importance of finding witnesses, that kind of thing.
Yes.
What if you, and if you did record them, you know, with their address, phone number, that kind of thing, but if you ask them some questions, are you able to use some of that if you needed it, if you ask about specifically the accident and what they saw?
Absolutely. Before we had those little recordings, what we would do is, for instance, if you were the witness and I read it, I said, "Did you see the wreck?" And Chuck said, "Yeah, I saw the guy run in the back end of you." One of the things that we used to do in the old days, I'd write you a letter. "Dear Chuck, thank you so much for talking to me about the accident. This memorializes our conversation wherein you told me you saw them run in the back end of my car. I appreciate that. If this is not exactly what happened, notify me in 24 hours. Well, if you don't notify me, we're going to stand on that. If you tried to get up and somebody persuaded you, said, "No, I didn't see it." I said, "Chuck, you remember back? I wrote you this letter. Is this your address?" So I have protected myself from a writing. So whatever it is, and if I had my assistant with me, I'd say, "Hey, you remember you shared with us back on the stage." So whatever creativity you can put together, let's put it together. And the odds are great, because if the insurance lawyer said, "You don't have anything," and I say, "You don't know, let me just show you," well, it brings everything to another level of settlement.
All right, very good to know. If you are just tuning in and joining us on Open Line, this is your forum, so that number is for you, 737-7587. You can give us a call, questions, comments. Kevin is the expert, those legal questions, and they help a lot of folks when you ask them personally. All right, so we are going back to our lines right now. Joe is on the line with us. Joe, good evening. Do you have a question for Kevin? You're on Open Line, Joe. Can you hear us?
Yes, I wanted to ask about, if you have a will redone, what should you do with the old will? Always destroy it or keep it in a safe place?
Good question, Joe. And usually in every will that's prepared by a lawyer, the first few lines is going to say, "I hereby revoke all pre-existing wills." So there's a revocation of that. Now, you remember you have one original. I could tear up the original, and that other will then becomes the original. So we like to destroy the old wills, and so that there is no misunderstanding. A good understanding keeps down a misunderstanding. So if I left everything to my friend Chuck, and then Chuck double-crossed me later in life, I'd say, "Golly, I can't leave this to Chuck. He didn't shoot straight with me." So then I would write a new will. And people write, some of the richest people we represent, they come in on a moderate basis and change the will. They'll write a child out when they were good. They'll write a child back in when they're not. And so it's not uncommon. I want you to get that will. It's a good policy to destroy the one previous. And then put that will with someone where they know it is, whether they put it in their lockbox or whatever, and use your best judgment so that that will be handled in the fashion that you want it.
And Kevin, also talking about wills, I know a lot of times people think, you know, well, I can just do my own written will and that kind of thing. But, you know, I think as people find over and over and over, there is so much that you really need to have in a will. And that's another reason that you need to talk to an attorney about getting that will.
Yes. Well, you know, there's a lot of lawyers that don't do anything but will contests. And granddaddy married a new woman, and now all the kids are getting cut out, and hello, come in. It begs for a will contest. And what are some of the things? Undue influence. Well, my brother went in on my dad's deathbed and had him write a new will and sign all these deeds. That's not fair. So what is fair? The courts, you go to a court of equity, and then you would have proof. If daddy really had his mind, or daddy had dementia. So, you know, it's not, if you've got someone that wants to leave, and it's really, you can always take him to a doctor and say he has his sound mind. And when we do those, people could even video the execution of a will. So that's more evidence. And then where you have 2 witnesses, if there's any dispute, my friend, let us have 3 witnesses. The more evidence, the better. It's clear. It's unequivocal. It's clear and convincing, as some of the opinions say. You got to have clear and convincing evidence.
All right, thanks for that. Okay, we're going back to our lines right now. Judy is on the line with us. Judy, good evening. We're glad that you're here on Open Line. What's your question for Kevin?
Well, good evening, gentlemen. I'd like to know, during a court proceeding, can either side of the attorney increase their fee?
Okay. Well, you know, attorney's fees are a private contract between you and your attorney. A lot of attorneys, when they come in, they ask for a retainer. That's common practice. Then they'll have a billable hour, whether it's $150 an hour or $450 an hour. That goes between what the lawyers are. So when you go to court, they're billing those hours. When they're preparing, and the courts require pretrial briefs. I remember we've had some of these cases, and I've even talked to some judges. It makes it better on the judges when everybody has a pretrial brief, but it costs money for people to prepare that. So that's some of the things that we're confronted with. But again, you'll always hear me. I talk to my lawyer. What do you anticipate? And then you can always say, I don't want to spend more than this. And then you come back and tell me. So a good understanding is always there. But so many of these fights, we got to put everything. It's kind of like a battle on the battlefield. We've got 100 men and 100 guns and all these bullets. We hope we don't ever have to use them. But if it's all out war, we've got to keep throwing that because we want to win. Remember, we're in it to win it.
There you go. And if you are joining us on Open Line, if you have one of those legal questions and you want some expert advice, this is the place to call, 737-7587. That number right there on your screen. As we go back to our lines
Chuck,
right now.
I want to say,
yes.
Chuck, before we get that line, I want to say one other thing that comes to my mind. When we know we have limited resources at the beginning, then we implement plans to try to get it settled. Plan A, Plan B, Plan C, and see the funds can carry us up to that point, and that'll give us the best spot for mediation, negotiation, whether we have a mediator or we even created the non-formal mediation. That's where you and I would meet with somebody and we try just to settle it among ourselves. So that's less expensive. Go ahead, Chuck.
And Kevin, just one more reason, that's why you need the lawyer's expertise, because, you know, just the regular layperson
totally
like myself,
agree.
they don't know that. So that is so good to know. All right, let's head to our lines right now. Brenda, you are on the line. You are on Open Line. What's your question or comment for Kevin?
I have a question. I had a relative that went into the nursing home, and she was paying Medicare, was paying part of it, and she was paying a portion. And
yes,
she was unable to continue paying it, so Medicaid started paying. Once the relative died, she was informed that they were going to take his property. Is there any way that you can prevent Medicaid from taking his estate?
Here's the deal. We have what's known as a 3-year rollback or a 5-year rollback. So people can sell their properties 3 to 5 years before they ever have to go into a nurse. So many people do not do any estate planning. That's why you should go and find out, because mama got sick. Well, we've got to put her in the nursing home. Well, you put yourself in a spot that the government's looking for their money. They're going to take care of you. But if there's any land, any house, anything in your name, they're going to have a lien on it. So before, what did I say? Let's talk about it 6 years or 7 years. If we see it, let us understand what we're up against. Talk to a private lawyer, and if we need to sell, if we need to do whatever, let's make some decisions privately.
All right, very good to know. Brenda, I know that's going to help, so once again, a good reason to give the lawyer a call. All right, Kevin, we're going back to our lines again. Patricia is on the line with us. Patricia, good evening. Do you have a question for Kevin?
Yes, good evening, gentlemen. I bought a house in 2003, and the year later, my property line changed. And I found out about a month ago from a title company that said my name was on my next door neighbor's property. I want to know, what can I do about it? I've been offered a quick claim deed to do. I'm not understanding why my name is on this other lady's property. Do you have any
one of the
suggestions on what I should do from here?
Yes. The first thing, I bought properties and been buying properties my whole life. And so some I didn't have it surveyed. Nowadays, you should, before you buy it, have it surveyed, because that property's been there, and you would say, this is in a subdivision and I think it's good. So it's called caveat emptor. That's Latin, let the buyer beware. So if you didn't get a survey, or there is a problem with the legal description in the deed, you know, we walk out there, it's clear, here's a fence, here's our yard, I'm buying this house. Wait. That's what you've run into. So you need to talk to a lawyer privately and see what your options are. Can you go back on the people? Maybe, maybe not. That's probably past your statute of limitations. But if there was some fraud involved or misrepresentation, we may be able to go back further. So meaning, if the owner of that property said, here's your property line, here's your property line, and you could establish that, then adverse possession comes in. There's a host of things that you just really need to let a lawyer research, both legally and then research what the deeds on these properties are. So that's what I'd say, do privately, and you get the information, then you and that lawyer make a plan how we're going to get out of this.
All right, we say it often, the law is complicated. That's why you need the experts like Kevin Kennedy. Kevin, we're going to take a quick break, but when we come back, more questions and comments here on Open Line. And the number is 737-7587. Come on back with us.